Hello there. Welcome to video 141 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. And do remember to like and share this video too. And if you want to drop in a line, I shall always be available at sumitacademy20@gmail.com. To make your task a little easier, here is a complete list of all the 141 videos on my YouTube channel. The list is divided into the playlists under which they are available. Do have a look. In this video, we shall talk about the Fugitive Economic Offenders, that is the FEO Act of 2018. An FEO, a Fugitive Economic Offender, is defined as any individual against whom a warrant for arrest in relation to a scheduled offence has been issued by any court in India, who has left India so as to avoid criminal prosecution, or being abroad refuses to return to India to face criminal prosecution. The FEO Act aims to provide for measures to deter fugitive economic offenders from evading the process of law in India by staying outside the jurisdiction of Indian courts, to preserve the sanctity of the rule of law in India, and for matters connected therewith or incidental thereto. Now the question arises, why was such a law required? Economic offences relate to fraud, counterfeiting, money laundering, tax evasion, etc. Various laws contain provisions to penalize such offences. Now, examples of such laws are Prevention of Money Laundering Act 2002, which primarily focused on containing money laundering transactions, and the Benami Properties Transaction Act 1988, which prohibits Benami transactions. In addition, the Companies Act 2013 prescribes penal and pecuniary, that is, financial measures for offences such as fraud and other unlawful corporate practices. Long-standing statutes such as the Indian Penal Code 1860 and the Code of Criminal Procedure 1973 also cover economic offences such as forgery and cheating. You see, you may commit an offence under any of the acts, but if you run away from India, then the FEO Act comes into play. If you come back to India, then you are no more a fugitive. Various recovery laws, such as the securitization and reconstruction of financial assets and Enforcement of Securities Act 2002, allows banks and other financial institutions to auction residential or commercial properties of defaulters to recover loans. The Enforcement of Securities Interest Act 2002 and the Recovery of Debts Due to Banks and Financial Institutions Act 1993 are also present but have not proved to be time efficient. Further, none of these statutes contain specific provisions to deal with high value white collar criminals who have left the Indian borders primarily to escape proceedings against them. Now, all these things, it forced the authorities to resort to extradition proceedings under the Extradition Act of 1962. However, it was seen that all these laws were falling short in addressing this issue of economic offenders fleeing the country and avoiding punishment. Moreover, the process of extradition is extremely procedural and time consuming. Factors such as the status of the international relations between the concerned countries, existence of an extradition treaty, nature of offence, etc., have a considerable impact on the manner and time frame within which the extradition proceedings progress. In 2017, the Finance Ministry released a draft bill to address cases of high value economic offenders fleeing the country to avoid prosecution. It observed that existing civil and criminal laws did not contain specific provisions to deal with such offenders, and that a new legal framework was needed to prosecute them. The ministry also argued that procedures under these laws were time consuming, and these things led to roadblocks in investigation and impacted the financial health of banks. So, in March 2018, the Ministry of External Affairs stated that over 30 businessmen under investigation by the CBI and the Enforcement Directorate had absconded, had run away from India to avoid facing prosecution before Indian courts. The last 3 decades have seen a rise in the number of cases of bank scams, chit fund scams, non payment of bank loans, etc. Names like Vijay Mallya and Nirav Modi have become synonymous with such types of scams. Many other such offenders have fled the country to avoid prosecution. So, what are the objectives of the FEO Act? This Act targets those offenders against whom an arrest warrant has been issued or their offences have been specified in the Act. The value of money involved must be over rupees 100 crores and the person should have left the country to avoid prosecution. Such offenders are declared as fugitive economic offenders. A special court is set up as per the Prevention of Money Laundering Act 2002 to confiscate the property of such offenders. The Act also aims to prevent such offenders from filing or defending civil claims against their property. Now, our next question is, what is the process for declaring an individual a fugitive economic offender or FEO? Under the Act, an application must be filed in the special court asking that a particular individual may be declared an FEO. The application must be accompanied by reasons for the belief that an individual is a fugitive economic offender. Any information available as to the whereabouts of the fugitive economic offender and a list of properties or the value of such properties believed to be the proceeds of crime. The special court may then issue notice to the individual to appear at a specified place. And of course, it will drop the proceedings if the individual complies. That is, if the individual returns, he will be tried as a criminal, criminal or an offender, not as a fugitive offender. If, however, the special court is satisfied that an individual is a fugitive economic offender, it may record so in an order along with reasons. The court may then order the confiscation of the properties of the accused individual in India or abroad. If you recall, the FEO bill was introduced in Lok Sabha on the 12th of March 2018 and passed by the Lok Sabha and Rajya Sabha on 19th July and 25th July respectively. The Act replaced the Fugitive Economic Offenders Ordinance 2018, which had been promulgated on April 21st of that year. That is, the government had first brought in an ordinance and then replaced it with an act. What comes to mind is whether this act was absolutely essential, or is it a case of a futile legislative action taken in haste to calm the agitated common man in light of the recent high-value monetary scams. Just like the Prevention of Money Laundering Act, this act makes a direct reference to various other statutes and includes scheduled offences as per those statutes, but covers a lot less offences as compared to the PMLA. The reasoning behind this narrow approach may be due to the fact that unlike PMLA, wherein confiscation and disposal of properties actually takes place only after the conclusion of the proceedings, this act provides for confiscation and subsequent disposal of properties, whether situated in India or abroad, on the mere declaration of an individual as a fugitive economic offender if the individual fails to return to Indian jurisdiction. Such a draconian section is bound to have a strong deterrent effect on the accused and will surely force them to surrender or at least appear either by their own selves or through an appointed attorney before the appropriate authorities in India. And that's what seems to be the legislative intent here. This seemingly arbitrary section was bound to receive some criticism for not being in consonance with a basic principle of justice, that is, innocent until proven guilty. The section is a major enabling provision for the Enforcement Directorate, the law enforcement agency, as it gives them ample power to search, seize, and attach properties even without commencement of any proceedings in a court of law. Further, the authorities may even dispose of the properties after a period of 90 days from the date of declaration of the fugitive economic offender. Now, this pre-conviction confiscation is not an entirely new concept. It has been laid down in the United Nations Convention Against Corruption, the UNCC, which India ratified in 2011. Article 54(1)(c) of the UNCC enables signatory countries to consider taking such measures as may be necessary to allow confiscation of such property without a criminal conviction in cases in which the offender cannot be prosecuted by reason of death or absence from the country. This act adopts the same concept. Such stringent provisions exist in various other statutes as well, such as the provision of forfeiture of properties under the Smugglers and Foreign Exchange Manipulators, that is the Forfeiture of Property Act 1976, provision of freezing of assets of a company by the Serious Fraud Investigation Office under the Companies Act 2013, and provisions of provisional attachment under the Income Tax Act 1961, among others. Although potential misuse or exploitation of this provision by the authorities is a valid concern, The intent of the legislature of compelling absconders to surrender has to be kept in mind too. The Supreme Court has held that the mere possibility of abuse of power is not a ground to strike down the provision on the basis that it is substantively unreasonable or ultra vires or unconstitutional. In any unfair cases, the court, by upholding the provision of law, may still set aside the action or order or decision and grant appropriate relief to the person aggrieved. Although the Act covers foreign properties and provides for a letter of request to be made to foreign states, the reality remains that India has a poor track record when it comes to extradition. More than 150 extradition requests are pending with various foreign countries. Thus, due importance needs to be given to strengthening of international relations, simplifying of extradition procedures, and culmination of more robust extradition arrangements and treaties. The Act places reliance on preponderance of probabilities as the standard of proof to be used by the special court. Although this is a lower parameter as compared to the general principle of requiring proof beyond reasonable doubt for prosecution of offences, the intention of the Act should be given due weightage. And what is that? It aims to bring the alleged offender within Indian jurisdiction and not adjudicate upon and or penalize the offender. So what we learn is that this act is meant to force the various offenders under the various existing acts. If they have run away from India, force them to come back to India to face proper trial. So what are the benefits of the act? It is expected to re-establish the rule of law, as the accused will be forced to return to India and face trial for his offences. This would also help banks and other financial institutions to achieve higher recovery from financial defaults committed by such fugitive economic offenders. And all this will hopefully improve the financial health of such financial institutions. Let us now have a bird's eye view of the important provisions of the Act. This Act has a total of 26 sections divided among 3 chapters. Chapter 2, the operative part of the Act, contains the provisions for declaring someone a fugitive economic offender and confiscating their properties. The first chapter has preliminary details such as the title and commencement of the Act and the mandatory definitions. An important definition contained in section 2(1) of the Act is that of a person. Now, what does the word person mean as per the Act? The application of the Act is not limited to only humans. It applies to legal persons and entities too. A Hindu undivided family, a company, a trust, a partnership, a limited liability partnership, every artificial juridical person, and any agency can also be brought under the ambit of this Act. An artificial juridical person is an entity such as a firm, and it is other than a natural person, that is, it is not a human being. But an artificial juridical person is created by law and recognized as a legal entity having a distinct identity, legal personality, and duties and rights. Legal personality refers to the ability of an organization to enter into legal transactions such as holding property or entering into debt. Now, chapter 2, as I said earlier, is the most important one. Section 4 of this chapter deals with the application for a declaration of fugitive economic offender and its procedure. Section 4 says that when a designated officer under the Act, now who is a designated officer? A director or any other officer not below the rank of deputy director believes that any person is a fugitive economic offender, then they can file an application as per the directions of the special court set up under the Prevention of Money Laundering Act, the PMLA 2002. This application must contain the reasons for such belief, any available information on the offender, the list of properties of such offender, and a list of persons who may have any interest in those properties. Next, Section 5 deals with the attachment of such property. It says that the designated officer can attach any property of a fugitive economic offender. Section 12 deals with the declaration of a fugitive economic offender. After an application is made under Section 4, a special court, if convinced, can declare an individual to be a fugitive economic offender. Upon such a declaration, the court may order the property to be identified and confiscated. But if after inquiry the court finds that an individual is not an offender, then it can release all such confiscated property. Now we come to Section 14. This deals with the power to disallow civil claims. This provision takes away the power of a declared offender to file a civil claim in any court or tribunal in India. This is to ensure that offenders do not delay the process of recovery of money by filing civil claims for their confiscated property. This ensures that there is swift and speedy justice for those wronged by the economic offence and quick recovery of money through confiscation of property. This section must be read in conjunction with Section 18 of the Act, which bars the jurisdiction of other civil courts in such matters. And finally, Schedule 1 of the Act gives a list and description of offences that are covered under the ambit of this Act. These range from offences under the Indian Penal Code 1860, offences under the Negotiable Instruments Act 1881, offences under the Reserve Bank of India Act 1934, offences under the Central Excise Act 1944, and offences under the Customs Act 1962. As I told earlier, you may commit an offence under any of these acts, but if you run away, the Fugitive Economic Offenders Act will come into play. If you don't run away, if you remain in India, then you will not be called a fugitive. Also included are offences under the Prohibition of Benami Property Transactions Act 1988, offences under the Prevention of Corruption Act 1988, offences under the Securities and Exchange Board of India Act 1992, offences under the Prevention of Money Laundering Act 2002, and offences under the Limited Liability Partnership Act 2008. Offences under the Foreign Contribution Regulation Act 2010. Offences under the Companies Act 2013. Offences under the Black Money, Undisclosed Foreign Income and Assets, and Imposition of Tax Act 2015. Offences under the Insolvency and Bankruptcy Code 2016, and offences under the Central Goods and Services Tax Act 2017 are also within the ambit of this act. Given the rise of economic offences being committed in our country, a robust law like this act was the need of the hour. It is particularly aimed at the big offenders turned fugitives like Vijay Mallya and Nirav Modi. Let us hope that it acts as a deterrent for such economic offenders in absconding from our country and leading comfortable lives abroad, and that India will be able to extradite such persons. However, extradition is as much a political process as it is a judicial one. The expeditious processing of extradition requests and the commitment to prepare for and defend the case before courts depends on bilateral relations and the opportune use of diplomacy and negotiations to push for the process by the requested country. India needs to take steps to dispel concerns regarding poor prison conditions and potential human rights violations of the requested person. India could consider signing international instruments such as the UN Convention Against Torture 1984 to establish India's zero tolerance towards torture and custodial violence. For addressing investigational delays, it is imperative to improve the capacity and organizational efficiencies of law enforcement agencies so that they may conduct speedy investigation in these cases. In fact, to ensure that India's extradition requests are in compliance with treaty conditions and documentary requirements, India must put in place suitable organizational mechanisms to familiarize itself with laws and regulations of treaty states. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject and not for any financial gain. Do like and share this video and do subscribe to my channel now so that you do not miss out on my previous and future videos. Till later then, cheerio.